Good afternoon, everyone. Welcome to the monthly Planning and Heritage Committee meeting. Call to order. Any declarations of conflicts? Approval of the agenda from May 1st. Okay. Adoption of the minutes from March 27th. Okay. Any business arising from those minutes? Okay, seeing none, we can move right on to our discussion items. We have 4. So we'll start off with the update on our short-term rental implementation file. I'll send that over to you, Alex, or CAO Mohammed, whoever is taking that.
I'll start on it. So thank you, Madam Chair. So in regard to the short-term rental bylaw, as the committee is aware, the zoning bylaw amendments come into place at the end of March. There was a number of questions raised at that time from residents, STR operators, council, others, in regard to how to, where to apply, where was the application form, which department did they apply through, how did they pay the tourism association levy, etc. So since early April, planning staff have developed the STR applications and residents can obtain their approvals through our office. Planning staff have been working with the province to ensure that all the city's STR approvals are mirror or that they're aware of the ones that we've approved to date. The Finance Department, Economic Development, and Planning have all worked on a question and answer sheet that outlines what is required from those who are seeking a short-term rental operation. And at this time, planning staff would note that there's no backlog of applicants seeking STR approval. And in closing, staff will continue to refine the application process and work with other departments to ensure that a more robust communication strategy is employed when the new STR licensing bylaws presented to council for later approval this fall. And the hiring of a bylaw enforcement officer will be very helpful in regard to providing a smooth implementation of the STR bylaw. Thank you, Madam Chair.
I just noticed you talked about the Q&A. That was supposed to be something rolled out through a communications plan. I don't see that anywhere yet on the website unless I've missed it.
So I did just check on that today, and so there's been sort of a back and forth between the communications team and our group in regard to where it sits on the website, and that they're trying to. Our people are trying to. The information is done. It's just a matter of there's some kind of a roll down menu where you can find that information, and they're just working to get that finalized. So that should be up today, early tomorrow. But there's been some back and forth in regard to just ensuring that it's placed on the website in the appropriate location and is easily accessible.
So, Madam Chair, clarify what is a Q&A? Question and answer?
Yeah, there was a number, high number of questions came in through email that weren't being addressed, and it was suggested that we take all of those questions and place them on the website as a, for people, because a lot of them are generic, and that was about a month ago. So there were just a lot of confusion around who can STR, when can you, how do you do it, if I live here, if I live there. There was just, I think there was about 40 questions that were combined.
Yeah, so through the chair, if it's okay to just ask Alex. Alex, so again, to clarify, when the amendments were made last year and passed by council with a 1-year grace, it was amending the official plan and the zoning and development bylaw to make short-term rentals your principal residence, correct?
Correct. Yep.
So if I was to ask a question about an STR, if I wasn't living in my home, then I can't rent it out, correct?
That is correct. But I guess what occurred is as straightforward as it is, it's always nuanced if I'm in a townhouse, if I'm in somewhere else. you're not allowed to have them in an apartment building. So there was a number of, and a lot of questions about the Tourism Association levy. How do I pay it? Where do I deal with that? So, again, there was, the first couple of weeks, there was some challenges in regard to getting back to people, but I think things have gotten kind of stabilized. Like I say, those that have applied have been, have gotten their approvals through the city. That doesn't mean everyone who was seeking approvals from the province last year have come to see us. But I think for the most part, people now know where you need to be to operate an STR. They know where you get an application, and then we will follow up with the licensing bylaw later this fall.
So, Madam Chair, just another question, supplementary question through the chair to Alex. So, Alex, I looked at the minutes here. We deferred the licensing bylaw, short-term rental licensing bylaw until October 31st. That application is ready. I think, what are we doing in between the meeting that we held last month and the 31st of October? Like, do we have a lot of work to do on it, the licensing?
There's been quite a bit of discussion with our city solicitors on that, and they don't think that there is going to be a lot of changes. But again, we do have some time to make sure that if there are changes, that we are telegraphing that earlier than when it's presented to council. That there will be a licensing bylaw at least proposed to council, and and that can be posted in advance, and so that people have an idea of what to expect. The licensing bylaw are the requirements that the city is basically imposing on the owner. These are your responsibilities. We will review and approve your application, but it's to lay both the city's obligations, but the applicant's obligation if they wish to pursue that type of land use.
Okay, thank you, Madam Chair.
And is there any update on the summary offense ticketing? And then there was also the fees, changes to the fees bylaw in terms of STR.
So on the STRs, it was deemed that the fee would remain the same until the licensing bylaw came in. So that will be in the fall. So the increased fee to recover the cost would come in at that time. And the directions would have to go to council to both approve the fee that's for the new licensing bylaw, and when that is all presented at that time as to what that fee will be. But in the interim, we're processing these applications for $50 as a tourist home, which we have historically done, and the work that was coming with the implementation of STRs had to do with the licensing bylaw, and then that they were licensed, and the licensing bylaw put a lot more onus on the city as well, and additional staff resources to get that implemented. So that's why the fee would be increased at the time that the licensing bylaw is brought in.
And the summary offense ticketing bylaw?
The summary offense, again, that's with Cox and Palmer, and it's been there a while. I mean, their issue is this is one component of why it's down there in our lawyers' offices, but it's all over the issue of providing ticketing and then which departments can ticket. And unfortunately, all departments that get enabling powers from different areas of the province, and you're restricted to stay in those lanes. And I think our lawyers were having some difficulty, but they can get it resolved in regard to how do we implement that ticketing process as effectively as we can and not run afoul of when we have to go to court. That again, these enabling legislations are all a little bit different in regard to what kind of a fee or a fine that you can charge for that type of offense.
So in terms of timeline, what kind of timeline do we have for the hiring of the new bylaw officer for the department, as well as the timeline for the summary offense ticketing bylaw.
So in regard to the hiring of the bylaw enforcement officer, that, that can happen, the department can work with the HR department to establish the job description, get that notice out in regard to that position is available and start the process to fill it. In regard to the summary offense, summary proceedings bylaw, I guess is what it's called. I can follow up with Mr. Hooley, but he's well aware of that is an outstanding issue, and it was his impression prior to the rollout of STRs that should be being brought back to council in the relative near future.
Thanks. Maybe I'll ask CAO Mohammed if there any more clarity around the hiring of this Planning and Heritage Bylaw Enforcement Officer?
Thank you, Committee Chair. The bylaw enforcement officer is in the top priority category for hiring. So we're just working through the process. We also need to develop the job description, and then we'll get it out. So it'll be in the first grouping of positions that we're putting out that were approved during budget. So in terms of timing, where are we now? May? Given it usually hiring for those types of positions 2 or 3 months, so maybe July, August, I think we can hopefully have someone. Thank you.
Thank you very much. Any other questions on STRs? Go ahead, Councilor McKay.
I'm still confused with the bylaw enforcement of the summary and fence ticketing. I know we've said it's kind of sticking towards, it's not just for STRs, correct? Like, there's a few items we're going to be discussing. I look at the noise complaint and things. Like, to me, that they're going to be able to incorporate other offense ticketing around that. Are they? Or are they not? I know we've had major discussion around this, but I'm just trying to get my head around what this job is going to entail.
Yeah, so when we've been discussing this with our lawyers, I mean, the bylaw enforcement officer who enforces some bylaws, the fire department who enforce other bylaws, they're all at these meetings. And then planning department enforces, planning related bylaws. So that is the intent, is to implement as effectively as possible some kind of a fining process that will hopefully make it easier to gain compliance. But I have to reiterate, if you don't pay the fine, you still have to go to court.
100%. But and right now, we don't have anything when people are not enforcing our
No,
bylaws.
I guess just to clarify that, we still have the same tools. The tools are there in the existing summary proceedings bylaw. We can take anybody to court for a violation. The issue that we're dealing with on this is how do we fine and create the ticketing, the fining process, because there was an email on recently in regard to something that was thrown out of court just on a parking ticket, and there was a bit of a precedent set on the parking ticket on just small little elements of there was something missing on the ticket or it didn't occur on the ticket. So the lawyers just want to make sure that when they bring this in, that there's a high probability this new tool, which would be fining, is going to prevail in court, because invariably somebody is going to not pay the ticket and we will take them to court.
And fair, but when something is black and white as, I just built a garage with an apartment above it and I didn't have a proper permit, and that's pretty obvious. I mean, at this point, this would give an opportunity to fine somebody for not following the proper procedures and bylaws, correct?
You are correct, but on something where somebody's expended a lot of money, the fine is not going to be the deterrent. It will be court. If you do something very significant, it will likely end up in court. Now,
That'll be outlined though in your process, right?
Right.
I mean, there's got to be some common sense that prevails in there too, right?
the purpose of the fine is to get somebody's attention. that there is a violation, that we are, it indicates if you don't pay the fine in this period, that you have to go to court, same as a speeding ticket. So that gets people's attention, and but on large issues, they'll still, dealing with multiple thousands of dollars, somebody will likely not be deterred necessarily by the fine, but they will be they have to go to court. Because it's the judge will dictate to them, you must comply. And that's the process that's been delegated to us from the province.
So, Madam Chair, if I could just follow up on that. I know we went through this issue on the unlicensed premises, so-called bootleggers, back in 2002, where the province had to change the legislation to declare unlicensed premises where alcohol was sold as public places. And therefore, they didn't require a warrant. The legislation was changed to, they could go into that public place, take all the, I think, possessions of crime. What's the term? There's a term there that contribute to the sale of unlicensed alcohol. So that would be the freezers, that would be, could be vehicles. And then the maximum fine, the first offense was $5,000, the second offense went up to $10,000, third offense went up to $25,000. And I remember speaking to then former Chief of Police Paul Smith, because I was on council at the time, and they always had to have a minimum fine and a maximum fine. So what Councillor McCabe described as building a secondary apartment unit above a garage without a permit, there would be a line item in our schedule of fines that would say, if you put up a building without a permit, it won't be a $50 fine. There could be a minimum of $500 to a maximum of $2,500. So that's why you had the minimum maximum fines. But Alex, to get back to what you said, where we're at, the place we're in since I was on council back 20 years ago is that we can't give them the fine. We have to take that person or corporation to court. So therefore, we become, would it be the defendant or the plaintiff? And the person that we're taking to the court is the plaintiff. So, but when you give a fine and if that person does not agree with it, he or she says, no, I'm not guilty. She goes or he goes to court as the defendant and we're the plaintiff. That changes the whole course of how we are able to get some deterrence in the system that we called our plan and development. So I know that the lawyers are working on it. They've been working on it for a long time. I don't think we're going to find a system that will be a tight, perfect system, because everything is challengeable, can be challenged in the law courts. That's the system we have. That's what they call due process. Not a lawyer, but I know this much. Due process is a fundamental right that we have in this country, in United States, any democratic country. So I just think we have to put something in place. It's going to be tested. It's going to be tried. But you know what? It'll be there. And I think if you look at the number of persons that do challenge a fine, I don't think it's the majority.
And if they're breaking the rules based on our bylaws and they challenge it, it's hard for a court to support a swimming pool fence. If you don't have a fence and you're fined and that doesn't do anything and they take you to court because they refuse to pay, a judge is going to say, do you have a fence? The answer is going to be no. Guess what? You're breaking the law because the law says you're supposed to have a 6-foot fence around your swimming pool. To me, it's just, let's get something rolled out so we have something when we put rules in place that we can enforce rules.
And I sorry, Madam Chair, but Mr. Forbes, I know where you're coming from. You want to make sure this is a lockbox proposal or a system that we put in, but a lockbox always has some way for someone to break it or to someone to open it up with a pin or a paper clip. I just think we have, we can move on with this as soon as possible. I'd like to roll it out. Hopefully, everything will be ready by October 31st, so we'll roll out the whole package. But just before I go, Madam Chair, could we get the number of principal owners or number of CTRs that have made applications? Can we get that? STRs, can we get that number just to see, are we up from last year? Or, well, we're not really up from last year because we didn't know, only based on what we got from the province. Do you have anything offhand?
Well, there's sort of a number of lists. So there's our list, there's the province's list, and their numbers. But there was a lot of non-compliance last year too, right? So that's even a bigger list. So, we know how many that we've issued, and we are slowly coming closer to the province for what the approvals that they granted last year, and now people are coming in to get their approvals. But the larger list is historically is that people that have not even got a provincial approval. But they only may rent once or twice, and depending on the outcome of the licensing bylaw, that may dissuade a lot of them from proceeding.
Indeed, a lot of work left. Anything else on STR before we move on to the update on the official plan? I guess over to you then, Alex.
So, Madam Chair, as you're aware, our consultants came down in March, did 4 nights of public consultation. The intent at that time was that they would, as a part of their contract, that they would take the information gleaned from the public participation process and input from staff. They would go back, they would assemble that, and then the intent was to put that information together and then provide an opportunity to brief council in regard to that the document was ready, but the intent was then to go out for a public meeting. It seems, and I'll take the direction, that there may be an appetite to have another round of public consultation. And if you wish to do that, that is outside of the scope of their current contract. I'd have to get a quote from them in regard to how much it's going to cost for them to do the next round of negotiation. I've provided some parameters in regard to where we are with that contract, but I think the key thing for you folks today is that they're suggesting that with your approval that they could do that second round of consultation on June 19th, 20th, 21st, and 22nd. Their intent was that they would have, if we didn't do the second round of consultation, they were to provide me a draft by the end of May in regard to what the current official plan would look like based upon that last round of consultation. So if they give me something, or if they're ready in May to present the changes that have been made, and we head out on the 19th, 20th, 21st, and 22nd, then you could update the public in regard to what changes were made since the last public hearing, another opportunity to educate the public in regard to that this initiative is happening. And then they would do the same thing. They would take that information, they would go back. It could provide an opportunity for then council to take a break over the summer and then bring back the whole document in September for a public hearing. So I guess what we're looking for today, Madam Chair, is just clarification. If you want to proceed in that matter, if you want a second round of consultation, and if you can provide me with those dates, I will work with the consultant to get some clarification that they can be here on those specific dates and what additional monies that will cost. There was additional money set aside in the budget to ensure that the official plan, there was some resources there to make sure that it did get completed. Thank you, Madam Chair.
Thank you. It's just a little unclear. What is staff's recommendation for what we do? I mean, you're the professionals on whether or not we should proceed to another round of public meetings.
I guess from the staff's point of view, the more consultation is always better than less. I guess when we initiated the contract initially, we were working off of that contract that they would only do the one round. So, again, it's just a matter of how much input we wish to seek. There is the resources to do that. And, if council so desires and wants to have a second round, I mean, I certainly don't think it's a bad thing to be engaging with the public more as opposed to less. Thank you, Madam Chair.
Thank you. Thank you, Alex. What do you folks think?
Well, I think the official plan is probably one of the most important plans that we'll ever do as a city, first of all. And it impacts later on, long time. We're dealing with things now where there's land being developed from a plan that was done in 2015 in East Royalty, for example. And here we are, and people are forgetting that in 2015 this was the plan, and they still are confused. I think the more we engage our residents, the better. I'm wondering, though, Alex, do we have to have 4 separate meetings? Like, I appreciate that we did that for the community areas, but what would be the cost difference if we went and had a big public meeting and allowed people to come in that were interested? I mean, there were people there, but it wasn't like it was people standing outside. And maybe if we had one nice spot where we could invite, again, people to come in and hear what the consultants have done, it might be more cost effective. But I also think that it's really important. That would be my suggestion.
So look, through to Councilor McCabe, to a certain degree, I do think if for those that want to engage, 2 evenings would be just as effective as 4. I mean, the 4 was really intended to ensure that nobody was unaware that it was happening. If we pursued those 2 dates and heavily promoted it, that it would be providing the public with an update of what has happened since March, and have a meeting in the downtown. It seemed the 2 biggest locations, I think that we had a response on. We had 3 pretty good spots, but the downtown we had a good response, and the Rod out in the West Royalty is a nice big venue, but the other meeting we had over at the Merchant Center was well attended as well. So either of those locations, but and to a certain degree, you don't want to fatigue people as well. That you're kind of always meeting on it. I don't think that would be. I think that's a good idea. Just to have 2 meetings, and it would be easier for the consultant to send a team down because they have to fly here, and but that's entirely a council decision.
I would suggest that if we did the Rod Royalty and then the downtown location, then they could be both live streamed.
Correct.
And that way it gives
Right.
the folks
Right.
an opportunity
Yep.
to be there and call in questions as
Sure.
well.
Yep, make a lot of sense.
And Madam Chair, just a clarification. So June 19th, 2021, 22, that's what we're looking at. You're proposing 4, we can go down to 2. But I'm just trying to figure this out. We're back and forth. So would that be the draft from our first 4 meetings? Or is that just more consultations from the first 4? Mr.
I think what you'd be doing at this stage is you would be indicating that it's getting pretty finalized in regard to that. That is the plan that they would like to present to council is a final document. You'll get some additional feedback, but if you don't set some parameters, you'll just keep going around and around and around.
So again, Alex, I'm just trying to clarify it. So let's say we go the 19th and the 21st.
Yep.
That would be their first draft.
Yeah. No.
Okay, so that's when-
They will show up with a finalized document, and then they would go in front of the public, and they would say, since the meeting in March, these are the changes.
Okay,
These are the
okay.
changes, and they're not, you have to leave the opportunity open for people to comment on these new changes.
Okay, okay.
But the reality is, no, we're
So we'll be looking at, not the first draft, this is the second draft. And just to clarify, so,
Correct,
okay,
correct,
there'll be
yep.
some changes.
Yep,
So
yep.
we're looking, instead of 19, 20, 21, 22, we'll take 2 dates of those 4.
Correct, yep,
Go
correct,
in the
yep.
downtown and 1 in the royalties. And just in the East Royalty Plan, that was, as was indicated, I think it was the group from Planning Partners from Toronto that came down and did that work. That's a separate document that was implanted in our official plan that was separate from the one that was passed in 1999. So there are lots of parts of the official plan and the zoning development bylaw that came from 1999. East Raleigh was updated in 2015 to look at how to make it more of a mixed community with commercial, residential, multi-apartment complexes.
My hope would be that this new official plan will incorporate everything and we'll have one official plan though. Is that
Oh, yeah.
correct?
Through the chair, yeah, the official plan is policies primarily. But in regard to a lot of what happened in East Royalty was enabling policies to allow for some creative zoning in that area. So the three plans that our consultants are from the official plan consultants, we have three fairly current plans: the downtown, the waterfront, the Eastern Gateway Master Plan, and East Royalty. Now there will be some changes, but they're not going back and going through them as if they were like from 1999. They're all relatively recent.
But our zoning and development bylaws will adjust accordingly to what our new official plan will.
Correct.
That's the next piece of work that has to happen as a result, correct?
Exactly.
Okay,
Yep.
and that will all kind of sum up nice where we can have it all in a nice place to
Right. Yeah.
find.
No.
That's going to be the work. That's the teeth of the official plan. And Madam Chair, proceeds of crime is what I was trying to refer to in the last STR issue. Thank you.
I believe that CAO Mohammed had a few comments.
Thank you, Madam Chair. In addition to having a little bit of extra public engagement, I would suggest that we could talk to the consultant about having a meeting with the developers of the city for their feedback. And then also, I know they've tried to reach out in the past, but reaching out to some of the communities in Charlottetown who aren't traditionally engaging with the city, members of the Black, Indigenous, and people of color throughout the community, just attempting to reach out to different groups again there. And then also just internally having it come around for the different departments to make sure all the departments are on the same page of what's being put forward. So some of that would be a little bit consultant, and some of that would be a little bit internal to planning. But you've seen for yourself with our 4 sessions of public engagement, we get very similar community members who show up for each one. And there's so much more diversity out there in our community that I think we just have to take that extra step to see if we can reach them. Thank you.
Thank you, Eleanor. That's a great point. Okay, so.
Can I just ask for a clarification on what that comment was? Would some of that consultation, though, happen prior to them coming to Charlottetown so that that would be part of the plan? That would happen before the June 20th, so that that would all be incorporated into that second draft that would be presented, correct?
I think they did have some pretty good input on Farm Day in the city, and I'm not exactly certain as to who they reached out to, but they did have a lot of commentary in the plan. So it's always doesn't hurt to loop around and go back through that process. But again, some of that preliminary work was done, but they did have a specific consultant dealing with that public engagement, and but we can follow up to make sure that those bases are covered, as alluded to by the CAO.
So, Madam Chair, just on that, so that's why O2 was brought in, correct? There was Upland Consultants and then O2?
Yeah, O2 is, sort of the big consultant, and Uplands have parts of it, including the public consultation component and the, working with various stakeholders. So we would be relying on them to do that extended public consultation.
And through the chair to the CAO, Madam Chair, the issue is that when you open it up for one group, you have to open it up to all. So there are NGOs out there. For example, the King Square Affordable Housing Corporation. There's also the Salvation Army. There's St. John's. They have a facility over in Stratford, St. John's Group. So, and then as you said, you have your First Nations, your Black BIPOC, Black Black, yes, people of, your BIPOC, those groups, we have to look at all these groups to be addressed. And will it require meeting with them individually, or is it, do you try to bring them into one? What are you, I'm just trying to clarify what you're suggesting, CAO.
Thank you, Your
Eleanor?
Worship, and through the chair. Some of it will just be, I think, emailing the document directly to those groups and asking for additional feedback. For the developers, I think that has to be an actual meeting with a little bit more input. And it's always important with land use plans that we check to see that the policies we're putting in place are actually buildable in terms of the development and scalable. So making sure that the developers can make the financial models work in order to build what's being proposed. So that's really what that circle back to the development community is about with the plan now. Thank you.
Okay, great. Anything else on that? All right. So we will move on to our next agenda item, which, yeah, this one is more so, yeah, it's in regards to the noise bylaw. And I believe it was a request for us to have this on the agenda around times in which people can make noise.
I did ask to have this put on the agenda because I've been with a lot of development happening. Thank you for making sure that happened, Deputy Mayor Yankoff. And I'm reading your report, Alex, and of course there are, again, another example of our summary offense ticketing when we have a rule in place where construction's supposed to happen not before 7 a.m. And I appreciate that it is a short season and you make money when the sun's shining, but it is disruptive to the neighbors. So I guess once our summary offense ticketing comes into place, we need to include things like this as well. I think any of our rules that we have in place in planning that that people can break is what we have to be thinking about when we do that. So thank you for.
And I just see the, one of the recommendations is to get some information out there through community and public engagement. So the more communication that we can get out there to remind folks about the times for noise, the better. And then therefore, no one's going to be able to say, well, we didn't know. It should be quite clear. So I'm thinking that there is a communications plan in place, CAO Mohammed, to get that information out.
I think what she's saying is sometimes if we put out a reminder to a PSA to say, don't forget, you're not supposed to be loud before 7 a.m.
We better choppity chop. We've got a few minutes. Last thing on the agenda is the, it's around the application fees that we had temporarily waived during the pandemic. Now, the staff is recommending that we reinstate the $400 application fee for the applications for the temporary use variance on these outdoor structures that happen during the summer months. Alex, did you want to elaborate any more on this?
Not really. I just, I think it was a very good initiative at the time. I think people saw those little igloos around town. There was outside decks. People wanted to be separated during COVID. We were trying to be as responsive as we could to the development community. But I guess the $64,000 question is, do they even want to do it any longer? But if they ask the question, is that fee going to be waived? I need to ask them. So it's this time of year that they would be getting ready if they did want to pursue this. So it's just here so that we have the answer. But staff feel that most of the restaurants have gone back to their pre-COVID, ways of operating their businesses, and it's no longer as pressing to have, either a deck or these small little structures in their parking areas. So, we feel that the waiving of that fee should likely come to an end. Thank you, Madam Chair.
I do believe that the Protective Services is in the process of working on the changes to the bylaw to encompass in all of those temporary structures that were put in place during Fiona to amalgamate them all into one bylaw. Is that not the case? Is that not what we're waiting on? I mean, we shouldn't be working in silos. We probably should all know what one department is doing about the other when it comes to these structures.
Yeah, Madam Chair, what can be confusing is the police deal with what's in the right-of-way. Any structures in the right-of-way, because it's it's a part of they administer all of the rules dealing with the right-of-way. What we're dealing with here is, when I'm saying parking lots, it's a parking lot on somebody's property. So, these are required parking for your business, and people were using them for these structures so that people could be separated during COVID. So the two are very, very different. So planning always deals with private property. We don't deal with the right-of-way. That's the police or others, Scott Adams.
I would suggest we look at our required parking spots for businesses. For me personally, I think it is an added bonus and feature for these businesses to have outdoor spaces in the summer. It's kind of what brings our city to play anyway. And I would rather see people gathering, eating, and spending money on a business than worrying about whether or not they can pull their car up and park. So I don't know if we can look at that.
I can't imagine some of the financial commitments that folks have put in place during Fiona for the summer months to have outdoor eating establishments on their private property, building of decks and things like that took away some of their parking. I can't even imagine that they would want to change that after all that money they put in. Do we know? I mean, so are we saying that we're going to allow them status quo as long as they pay the $400? Or is it that they have to reapply every year? Because I don't know if anyone knows that.
They do have to reapply every year unless you change the bylaw. And that when you finish the official plan and are into the zoning bylaw, you can have that review of parking in general in the downtown.
That's what it is, Madam Chair. Every year we have to reinstate the outside patios through a bylaw, through a vote. Yeah. So it has to be done every year. That's why they're referred to as temporary.
Yeah, but he's not referring to the ones that are on cities right away. He's talking about ones that are on private property that were different during COVID.
And there's not really that many of them. I think in the peak of the COVID, there might have been 5 or 6. There's not a lot of restaurateurs, so it is on private property. If you think of the restaurant on Kent Street, they have the little igloos there. They were out in their parking area, their required parking. So, but again, they may have adjusted to that, and people no longer want even exercise that option. They may now want back in the physical restaurant as opposed to being outside.
So again, just for clarification, Madam Chair, this is the recommendation from staff. Staff would suggest that the planning committee direct staff to reinstate the $400 application fee for those seeking this type of variance moving forward. So the variance is for on private property.
Correct, yeah.
And also our parking spaces, correct?
Not our parking spaces. It's their parking spaces. They're required in the bylaw to provide a certain amount of required parking. What they were doing is they were removing their required parking, and they were putting these structures over their required parking.
Okay.
So where customers would typically park.
Okay.
Because it was so quiet in the downtown, there was lots of places that they could park.
So we're asking for the reinstatement of the $400 fee, correct?
Yep, correct.
And I would suggest that we clarify the confusion around what's happening in police services and what's happening under planning and heritage, because they're very, very similar, but kind of different, and it's going to confuse the public because it's kind of confusing.
So it'll still have to come back here because this is a planning issue. This is not a police issue. This is a planning issue. This is a fee from planning,
Yep.
development, and heritage.
Right.
And again, just keep in mind that it's just, if there was no COVID, we would not even be discussing this. This was a temporary measure that was deemed to be helpful to the development community who was, our restaurateurs who were struggling. It was, and now things have seemingly gone back to, I wouldn't say normal, but back to pre-COVID, somewhat pre-COVID conditions. So we're just asking that we get some direction on it. Thank you.
And they can still apply to put a patio there, lose their space, pay $400 and have that opportunity.
They can.
Okay.
Yep.
I'm okay with moving that forward.
Any new business?
Nope.
All right.
Did we miss one item?
No, we got them all, Alex. There was update in short term, update in official plan.
The only thing
noise
that wasn't on the agenda that I had asked for on the agenda was just, you know, this is your, actually, Alex's very last planning committee meeting, so we'll miss him when he leaves. And I think we were just looking for a little direction on who we might be looking towards for our direction in the interim. And hopefully we'll get that direction at some point.
We will, Eleanor and I will speak, the CIO and I will speak, and I'm sure we will have something to provide to you shortly.
And we're lucky too. The CAO is a national, international planner.
Yes, but they're busy too. They're not here to take over the planning department. Okay, motion to adjourn. Okay. Thank you,
Thank you.
everybody.
As we move into adjournment, I want to thank Alex for his great work.
Thank you.
Over how many years, Alex? 10 years?
Almost 10 years.
Well, thank you very much, and I really appreciate it.
10 years less a day.
You're not going to prison.
Thanks.